of the evidence was, or the ruling was contrary to the weight of the evidence. Please don't hear any disrespect whatsoever in my argument as to the trial court. Judge Joe Binkley is an excellent judge, and I've been in his courtroom late at night on many an occasion. I have the utmost respect for him. I think he just made a mistake in this particular case. I've got to point out, and I might have to read just a little bit because I cannot recite from memory all of the undisputed facts that were set forth at the trial of this case. There's 10 of them that I would like to focus upon, and these are all annotated appropriately in my brief. The first undisputed fact is that this is Metro's valve. It's their property. There's no question about that. Secondly, Metro serviced this valve on July 11th, 2019, and had to lift the lid to do so. William Long was the repair person who did that service. 3, Ms. Ware's accident occurred September 7th, 2019, within 60 days of the service performed by Metro. 4, it was undisputed that the lid was not properly on September 7th, 2019. I've got that admission straight from Mr. Long, who was the repair person who serviced it previously. 5, the lid was loose and it flipped up when Ms. Ware stepped on it. 6, there was no proof or evidence of any kind of anyone touching that lid between when Metro serviced it and when the accident occurred. 7, based on the photographic evidence of the lid on the day of the accident, each Metro employee testified that because of grass that was inside the box itself, which is Metro's responsibility, not the homeowner's responsibility, but grass inside the box itself, that there was no way that the lid could have been on securely. 8, William Long, the Metro employee who serviced the lid on July 11, 2019, had no memory or recollection of anything. And the work order that shows his repair, he did not dig out this meter box. And then, most importantly, 9 and 10, Larry McClanahan, another Metro employee who's the supervisor of William Long or in a position of authority over him, testified that reviewing the photos on the day of the accident, the valve and the lid would not have looked like it did had Mr. Long dug it out, of which he has no recollection. And 10, the grass inside the box itself was preventing the lid from seating. It was not going down inside the recessed lip of the frame, nor could it. It was impossible for it to do so because of the condition of it that are reflected by the photographic evidence of the valve on the day of the accident. So I've got, how many cases especially in a GTLA context, do you have a witness from the government, from the municipality, who gives you favorable testimony? Larry McClanahan was the witness that I relied upon at trial. I had deposed him. I knew what his testimony was going to be, and he gave me exceedingly favorable testimony on behalf of the plaintiff against Metro, that there is no way that that lid could have gone on in the condition that it was in on the day of the accident because of grass that was coming out from inside the box itself. Now, the trial court was recovering from illness at the time that the trial court heard this case. In fact, took a break to take medication at some point during the trial. I simply believe that the trial court missed it because it failed to hear and appreciate the testimony of Larry McClanahan. Larry McClanahan, when we were sitting in my office taking depositions, 2 years to the day after the accident, plaintiffs disclosed to the defendants, it's still like that. This lid is still like that. Larry McClanahan went and did a post-accident view of this lid, looked at it, had to dig out 3 inches of soil to get that lid to go down flush inside the recessed lip of that box for the lid to go on right. Now, I obviously asked him about that post-accident inspection at trial. What I believe the trial court missed was his testimony regarding what he found when he looked at the photographs from the accident or from the condition of the lid on the day of, when those photographs were taken on the day of. And I would submit to the court that one look at exhibits 2, 8, and 9 in the trial transcript, or in the technical record, the court file, will show that there was no way that this lid was properly seated by Mr. Long, who had no recollection of anything. Now, those are the undisputed facts. What is the law? First of all, there is no presumption of correctness as to the trial court's findings regarding conclusions of law. That's a de novo review for this court. Secondly, there's no presumption of correctness as to the trial court's findings regarding the testimony of Larry McClanahan related to his view of the accident photos on the day of the accident, because the court didn't make any. The court did not make any findings in that regard. And lastly, for the plaintiff to meet her burden of proof, she does not have to eliminate all possible causes or inferences other than defendant's negligence. She only has to show that the evidence for her case makes the defendant's alleged or inferred negligence more probable than another cause. So what is more probable? Metro defended this case on the basis of, well, you know, anything could have happened out there in the 58 days between when the service occurred, when the accident happened. But there was no proof of that. They suggested to the court over and over, a lawnmower could have run over it and dislodged the lid, a car could have hit it and dislodged the lid, somebody could have vandalized it. There was no proof of any of that. In fact, every single one of Metro's employees who examined the lid, William Long, Prentice Reagan, Larry McClanahan, each one of them who examined it said there was no evidence of anything wrong with this lid of any kind. In fact, when Larry McClanahan reapplied this lid on his post-accident review 2 years later, he used the same lid. There was no proof or evidence of any kind of any tampering or damage to that lid. Without proof of that, what is more probable? Anything can happen, or the photos of the lid on the day of, revealing it to be in such a condition, which is supported by the testimony of Metro's own employee, its own witness, of there's no way that lid could go on securely in the condition that it was in. Through the course of the trial, I asked numerous Metro employees, not looking for an answer of, well, it's possible. I asked questions that I received a response from that said, well, it's possible. And the court said, hold on a minute, let me stop you right there. I find that questions of, or something being possible is not proof of anything. I wasn't eliciting those responses, but those were the responses that I was getting.
Didn't the court rely on habit evidence?
Yes.
With regard to Mr. Long, Mr. Long said that I know I must have done that because that's the way I always do it.
Exactly.
And that he said had he, if it was necessary to remove the grass or remove dirt or whatever, that he would have noted that on his report.
And there's no notation on the work order of that day of him doing that, and that's where I'm, Judge, the substantive law for the GTLA is that it removes immunity for any injury caused by the dangerous or defective condition of any public improvement owned or controlled by such governmental entity. How can a plaintiff win any case if the testimony is, well, I don't have any recollection of anything, but I know I do it right. I know I did it right because I always did.
I guess my question is, that's the basis on which the court decided the case.
Yes, sir. On habit and practice evidence from a witness who did not recollect anything about anything, only I know I did it right because I always do. The testimony was he does 4,000 service calls a year, 20 a day. And his testimony was, I can't remember anything. I just know I must have done it right because I always do.
I guess my question is, can we reverse the trial court if there's evidence to the contrary? In other words, if the court's basing it on this habit evidence, can we reverse him on that if there's evidence that it could have occurred a different way? Which I think is what you're arguing, that it occurred, it more likely than not occurred a different way. But is that sufficient to reverse?
I believe it is, Judge. The testimony of Mr. Long was severely controverted by the testimony of his own supervisor. Well,
The judge credited all the witnesses.
yes, sir.
He credited Mr. McClanahan and he credited Mr. Long. He credited all the, he said, I think all the Metro witnesses, he said were credible.
I believe he did, and yes, and so that means that he didn't make specific findings of fact as to Larry McClanahan's testimony regarding McClanahan's testimony as to what I asked Mr. McClanahan. But to answer your question directly, the testimony of Mr. Long was controverted severely by the testimony of Larry McClanahan. And Larry McClanahan was in a position of greater authority than Mr. Long. When Mr. McClanahan reviewed the evidence and said, there's no way that lid could go on correctly looking at these photographs. I've got them right here.
Are you saying that he could not have credited both witnesses' testimony?
No, sir, I'm not saying that. I'm not saying that. He can credit the witness's testimony, yes. I'm saying to the court.
No, I'm saying, can both witnesses' testimony be correct?
Well, if one controverts another, then here's what, as I read the transcript.
That's what I'm trying to ask you.
Right, okay, that's what you're trying to pull out of me.
Right.
Okay.
I mean, you've got a supervisor who said this couldn't happen this way, and you've got the person who did the job saying it wasn't like this. So apparently there is an inconsistency there, and the trial court, based upon what I've heard thus far and what the briefs say, said you're both right. So how does that work?
Yes, sir. So I would suggest to you that the testimony of Larry McClanahan controverts the testimony of William Long, and this court can reverse because that is contrary to the weight of the evidence. Because Larry McClanahan's testimony was not controverted. It wasn't rebutted. It was not rebutted. And it's Metro's own witness.
So what do you have to show us then for us to determine that Mr. McClanahan's testimony is more accurate than the other witness? What's the standard you've got to get to for us to be able to do what you're requesting?
There's not a presumption of correctness, and I would submit to the court that there's not a presumption of correctness as to the testimony. Judge Binkley did not find for the testimony that I listed from Mr. McClanahan, he didn't make a finding in that regard. That is not subject to a presumption, and this court can independently review that testimony. My ask of this court, please, is to please look at the trial transcript, page 74 to 90. It's only 16 pages, and in conjunction with that, please look at the exhibits, the photos. One look at those. Mr. McClanahan's testimony is right, and it supports only one logical conclusion.
Let me ask you, the photo that you're referring to was taken 2 months after this incident where Mr. Long serviced the lid. Is that right?
That is correct, Judge.
So we don't have a picture of the condition in July of 2019?
No, sir, we don't. But what we do have, go ahead, Judge, I'm sorry.
No, go right ahead. No, you answer that.
What we do have, however, is we have testimony from Mr. McClanahan that he dug it out and that there is no way that it was going to look like this had Mr. Long dug it out the way he was supposed to.
And this lid is on property owned by what party?
It was the plaintiff's sister. The plaintiff is not the landowner.
The plaintiff is not the
She was visiting her sister.
her sister's home.
That's right.
And it is a front yard, as
Yes, sir.
I understand it.
Yes, sir.
And it is a yard that you would cut with a lawnmower.
Yes, sir.
Was there proof that it had been cut between July and September?
There was no proof of that whatsoever, and there was no proof of anything happening to that lid in any shape, form, or fashion between the time of Mr. Long's service call and the time that my client stepped on a loose lid and broke her foot.
So we don't even know whether or not the yard was cut between July and September?
No, sir. There's not testimony of that in the record.
But grass would grow between July and September?
Certainly. It certainly would. But Larry McClanahan testified that in the state that it was in, based on the photographic evidence, it would not have looked like this had Mr. Long done it right when he serviced it on July 11th.
Thank you. We will hear from the appellee.
Good morning, Your Honors. Andrew McClanahan, representing the Applee Metro Nashville. First, I want to say there was an assertion made that Judge Binkley was under the weather when this case was tried. I've been in front of Judge Binkley, like opposing counsel has, many times, won some and lost some in there, but what I can say unequivocally is that Judge Binkley was neither diminished nor infirm when he heard this case, and I am confident that he heard all the evidence and made the appropriate decision. This case is a case of circumstantial evidence, and what we're asking this court to do is uphold the trial court's decision that the appellant failed to prove by a preponderance of the evidence that Metro's inferred negligence was more probable than any other cause. The trial court's decision in this case is supported by the weight of the evidence. Its findings were reasonably drawn from the evidence before it and were based in large part on the credibility determinations it made during trial, particularly Metro's witnesses and especially William Long, whose alleged or inferred negligence was central to plaintiff's theory of liability. And as this court knows, that trial courts are particularly suited to judge the credibility of witnesses because they see and observe the witnesses, and that should not be disturbed on appeal absent clear and convincing evidence to the contrary. Let's talk about what appellant's case actually was, and we've heard a lot about Larry McClanahan, who, by the way, is no particular relation to me, but we've heard the testimony about Larry McClanahan. What we know about Larry McClanahan is that the beginning and ending of his knowledge begins on October 7th, 2021. That is 2 years after William Long went out there and worked on this water meter, which occurred on July 19th of 2019. That is 2 years after Wanda Ware fell in the hole on September 7th of 2021. That is also something that you haven't heard about, which is the testimony of Prentice Reagan. It is 17 months after another Metro Water employee went out there between the time that plaintiff fell and the time that Larry McClanahan went out there, and that is Prentice Reagan. He testified at trial. The trial court found him to be credible. And what's of particular note to Prentice Reagan is while he was out there, he had a conversation with plaintiff's sister, Margaret Malone. And Margaret Malone told him, hey, by the way, my sister fell in this water meter hole some months back. That impressed upon Mr. Reagan to make sure that the water meter lid was on when he left that day. And the trial court noted in its order, and this was one of the questions that was asked, how can the trial court credit Larry McClanahan and Prentice Reagan? The trial court questioned the relevancy of Larry McClanahan's testimony for that reason and other reasons, but it doesn't matter what Larry McClanahan found if there's been another employee out there who made sure the lid was back on. Larry McClanahan also testified in cross-examination that he doesn't know what conditions that William Long encountered. He was out there 2 years after the fact. That's 2 mowing seasons. That's 2 rainy seasons. That's 2 years of nature's forces and man's forces working upon the land.
Isn't the evidence, though, that the plaintiff is relying on is not necessarily what McClanahan saw 2 years later, but the photographs that were taken on the date of the accident, which was 58 days later? Isn't that the evidence that the plaintiff is arguing about? Is that McClanahan testified that his view of those photos was that the hole couldn't have been cleaned out, like Long said would have happened in his habit if it was needed to be within that 58 days.
I think the evidence shows in the record that Mr. McClanahan is being asked a series of hypotheticals, and he acknowledges, I don't know what Mr. Long encountered that day. I've never spoken to him. I've not seen a photo of what it looked like on that occasion. There is no policy or procedure, and both Mr. Johnson and Mr. McClanahan testified to this fact. We don't carry lawnmowers and weed eaters on our trucks. We don't have a policy or procedure to make the yard look nice. That's the landowner's responsibility. Our job is to make sure that lid gets securely in the frame, no matter how that can be done. And the fact that that is the case, that if you can take a screwdriver and take it around the rim of the lid and get out any dirt, that's acceptable. If you can simply push the grass out of the way and put the lid back on, that's acceptable. If you pull some grass out of the way to get the lid back on, that is acceptable.
But did McClanahan testify that based on the photographs that he saw that were taken on the date of the accident, that the lid could not have seated properly on the date of the accident? Based on the condition of the hole that he saw in those pictures that were taken 58 days later?
When he gave that testimony, Your Honor, I submit he was testifying to a hypothetical. And if his testimony can be characterized in that way, it is simply not relevant and not a qualified opinion. And he admits on cross-examination that he doesn't know what Mr. Long encountered. And the fact that there's grass growing in there, Mr. Long submitted, if there was a problem with there, I would have noted it in my record. I didn't note anything like that in my record. Mr. Long also testified, I do 20
So
to...
that's conflicting, I assume, at least that's conflicting evidence, and that was what I was asking plaintiff's counsel. In other words, what McClanahan basically has said, based on the hypothetical and based on his review of that picture where he says it couldn't have, the top couldn't have seated, is in conflict with what Long testified to, that he would have, had it been that bad, I would have cleaned it out. And my habit is to put the lid back on, step on it, and that's what I did, and that's all that was necessary. That's conflicting testimony.
It is somewhat conflicting, but you have to go back to this point. And I think it was one of the questions that Judge Armstrong asked is, we don't know if any mowing had occurred, but we do know this is the summertime. Mr. Long was out there in July of 2019, and plaintiff's incident occurred in September of 2019.
Well, let me ask you a different way. Let's assume it's conflicting. The court's the finder of fact. The court has to determine what weight to give to both witnesses' testimony. The court found all the witnesses were credible. And that's essentially what the court did. The court weighted Mr. Long's testimony, his habit testimony, over the hypothetical testimony of Mr. McClanahan. Would you agree that that's what's happened here?
I would not agree, Your Honor. I think if you look at the totality of the trial court's order and what it's saying, and the fact that it questioned the relevancy at all of Mr. McClanahan's testimony, when the trial court is speaking about the credibility of witnesses, I think it's more in line with the trial court discussing the process and procedure that all these employees testified about when they're talking about how we get the lids back on. Each employee testified, when I lift a lid to do a repair or for whatever reason, we make sure the lid is seated back in the frame by stomping on it. And if you look through the transcript that's attached to the trial court's order, that's when he's saying, and I find all the witnesses to be credible. So I would submit that credibility determination is more about the process and procedure for getting lids on, rather than saying, oh, this particular portion of Larry McClanahan's testimony where he's possibly giving an opinion on whether or not this lid could have been put back on based on a photo that he saw that Ms. Ware took on the day of the incident, that the lid couldn't go back on. I don't think that the two are conflicting if you really distill down into the record itself and read the trial court's testimony and what Larry McClanahan actually testified to.
Let me ask you, is there any proof about whether or not the weight of a lawnmower riding over that lid would displace the lid cover?
So we heard, in the case, we heard testimony from Mr. Johnson and also from Mr. Reagan that this particular meter itself is a residential water meter lid. These are not the same as the ones you would find out on the street. They're not as thick, they're not as heavy, they're not meant to be drived over. William Long and I believe Mr. Johnson also testified to the fact that lawnmowers can dislodge these lids. Cars driving over them can dislodge the lids. If people are parking in the yard, there was some evidence that there had been cars parking in this particular yard, although no specific evidence of right on top of the meter box itself. This lid was located in the front yard of a home. We heard testimony from all Metro Water employees that these lids are accessible to anyone. There is no law, rule, or regulation that prevents anybody from lifting these lids. And people do that for all kinds of reasons, or sometimes for no reason at all, or perhaps even mischief. And the trial court credited some of that testimony, finding that strange things have been found in meter boxes. It's also particular to note that Metro has over 150,000 to 200,000 residential water meter lids. It doesn't have the ability to have surveillance on these lids. There's no alarm on the lid if it's been lifted or dislodged. In this particular case, there was no call to Metro that this lid was dislodged in any way from the time that William Long went out and worked on the lid until plaintiff's incident. And one of the cases that I would like to direct the court to that we cited in our brief is Jenkins versus Big City Remodeling. And that is a res ipsa case, but as courts have found, the proof presented in a res ipsa case or a case of ordinary circumstantial evidence is pretty similar. And in Jenkins versus Big City Remodeling, I think it's instructive to look at that case. And there was a fire in the back of a home, and the cause of the fire could not be determined, but it was on a back deck, accessible to the public. There was some testimony that some workers who were working on the home had smoked some cigarettes and possibly improperly discarded some oily rags. In that circumstance, even though there was work being done, the Supreme Court was unwilling to find that the plaintiffs had proven their case in that instance. And what it says is the plaintiffs relying on res ipsa loquitur to establish an inference of negligence do not get a free pass on the burden of proof, nor does the burden of proof shift to the defendant. The plaintiff must submit evidence that establishes a rational basis for finding that the plaintiff's injury was probably the result of the defendant's negligence. The event, further it goes on to say, the event that caused the injuries of a kind that ordinarily does not occur in the absence of negligence, that's something that has to be shown, and other responsible causes, including the conduct of the plaintiff and third persons, are sufficiently eliminated by the evidence, and the negligence is within the scope of the defendant's duty. That's our case here. 58 days had passed since the time that William Long worked on this meter until the plaintiff fell. We know these water meters are accessible to the public by the street, can be accessed by anyone, can be damaged. Those are all the circumstances that surround this meter. And under the evidence of this case, and crediting the testimony of William Long, the trial court was properly unwilling to find that Metro's inferred negligence was more probable than any other cause.
Is there a sidewalk at this location?
I don't believe there's anything in the record about a sidewalk at this location, Your Honor. Finally, one of the other things that's been brought up in this case is the case Moreau versus the city of Madisonville. That case does have some facts that are similar to this one. In that case, though, it's a 2.5-page opinion. There's only 3 or 4 sentences in that case about what the proof was, but in that case, a city employee had worked on the water meter shortly before the plaintiff had stepped on it, and it had flipped up and the plaintiff fell on it. Appellants in this case have repeatedly insisted that that case is instructive here, and that it requires the trial court and this court perhaps to rule in their favor. All that case really stands for is that cases of circumstantial evidence, the trial court may rely on circumstantial evidence or direct evidence or a combination of both. And when the trial court reasonably draws an inference based on circumstantial evidence, it will not be disturbed on appeal. That's it. That's all that case says. It doesn't establish a bright line rule for this case. And moreover, what it says is, in every case of circumstantial evidence, the trial court has to consider the unique evidence before it, weigh that evidence, and then make a determination. That is what the trial court did here. It found Mr. Long to be highly credible, and a lot of it was based on habit evidence. Mr. Long could not possibly remember what he did out there that day without looking at a work order. He does thousands of these a year. There was no evidence in the record that he was a bad employee. In fact, he was a 19-year employee, never had a problem with lifting lids, never had a situation where he had been brought up on a claim for putting a lid on it properly. The trial court said he just told it like it was. He didn't embellish it. He said, each time I do that, I put the lid securely back in the frame. I stomp on it. I make sure it's secure. I make sure it's safe. I know it's a safety issue. That's what the trial court credited. That's what should be held on appeal, Your Honors. Thank you.
Thank you. I believe you have 2 minutes in rebuttal.
Thank you, Judge. Very briefly, and this goes to Judge Armstrong's question a moment ago too, as to grass cutting. We're not saying that it was lack of cutting grass or anything else, that there was grass inside the box itself, and the undisputed testimony is that grass inside the box, that's Metro's responsibility. So if you look at page 88, and this is not a hypothetical, this is a put the picture on the screen for the witness to look at, and I'm questioning Larry McClanahan, do you see in that photograph, it was exhibit 10 to his deposition, it's exhibit 2 at trial, grass all inside the box, preventing it from seeding? Answer, I see grass, yes. Question, preventing it from seeding, correct? Answer, correct. So if that's the way it looked on the date of the accident, there is no way that lid could go down and seat properly. Answer, yes.
If it looked like that on the date of the accident, was that the answer he was
referring? Yes, sir.
He was responding to?
Yes, sir. Referring to the grass inside the box itself, which the landowner homeowner is not going to take care of, because that's Metro's responsibility. And that grass inside the box itself was preventing it from seeding. So what's more probable in this case is the question that something happened out there between when Mr. McClanahan serviced it and the accident occurred, when there's no proof of that whatsoever, and I was even admonished of anything's possible, there's no proof of anything.
But how does that, did he say that it would have looked like that? Or could he have even said that it was like that on the day that Long serviced it?
Could it have looked like that on the day Long serviced it? Well, he testified that had Long dug it out the way Larry McClanahan, dug it out when he did his post-accident investigation, it would not have looked like the pictures that were presented at trial. The plaintiff cannot take a picture of a lid from July when Metro services it.
But I guess the question is would it necessarily have been as bad or as dramatic in terms of the grass growing that would have kept the lid from seeding on the day that Long serviced it? I mean, do we know anything about that? Did McClanahan testify that it would have been like that 58 days earlier? He can testify, the picture you showed him was 58 days later. He didn't testify that it was more likely than not in that condition on the date of the accident.
What he testified to is that because of grass inside the box, there was no way that lid could go down and seat inside the frame. And and based on his experience, what he saw, his experience in the field, the reason it looked like that is because it wasn't dug out when William Long serviced it.
Let me ask you, sidewalk or not? Was there a sidewalk?
No, sir. There was not a sidewalk on this particular on this particular home.
So this cover is fully in the front yard of the plaintiff's sister, and it is a yard that you would normally cut. Is that right?
Yes, sir. And it was the yard that she walked to get to her car that was parked on the street. And the plain testimony is that Metro understands that people walk in their front yards and they got to put those lids back on right. Okay.
All right. Thank you, counsel.
Thank you, Judge.
We appreciate your argument. We appreciate your briefs. We will take this matter under advisement and